Okay, so thank you everybody for being here. We're excited to share with you tonight. My name is Jenica Williams. For those of you who don't know me, I know some of our clients are on tonight, and so I'm glad that you're here. We are going to be talking about estate planning with attorney Daniel Hunt, and we're excited to hear from him. So part of the reason I guess that I wanted to do this class or seminar is that we have had clients previously who have dealt with probate and not had a trust, and it's been really challenging and emotionally challenging after losing someone to not have everything in order. So we're really passionate about estate planning, and we also are trust and probate certified because of that. And we just know that grieving is really hard, and it's harder when things aren't in order, your loved ones don't know where your things are, and there's just a whole layer of things that go with not having your estate in order. So today, that's what we're going to talk about, and I'm excited to listen in and share, and also Daniel has so much information to share with us. So a little bit about us. I have been in the real estate industry for almost 20 years, and Deanna Roth, who's also on this seminar here with me together, our experience is about 35 years. And we have 2 realtors on our team, 2 administrative assistants, a transaction coordinator, and we just love what we do. We're in the top 5% of our office, and we really just pride ourselves on the service that we provide to our clients and try to provide value throughout our relationship with our clients, even after you get your keys or sell your house, with events such as these. So this just talks about estate planning, what it is. So you want to make sure that your assets, including real estate, are managed and transferred according to your wishes. Dan will touch a little bit on minimizing taxes and some of the strategic ways to do that with estate planning, just so that you have peace of mind for you and your family. So with real estate, putting your home in a trust, when you're going to purchase your property, you can do it right away on the contract if you have a trust already. So we'll ask that in the transaction is, do you already have a trust? Do you want to buy the home in the trust? If not, and let's say you don't have a trust today, but you are going to get one, you can always put your home in a trust easily. Sacramento Deed Services is who our title company uses, and they can prepare the documentation and then get it recorded so that your home is in a trust. So you'll transfer the title. That's what that does. You do want to maintain the trust and periodically review that so that it aligns with your goals. So for instance, in my family, my kids are getting a little bit older now, so our trust needs are changing. We might need to change some things about who would care for our children should something happen to both of us, as our own parents are starting to age. So there's just different things where you do want to review that every so often and update your trust with your attorney. So some of the obstacles, you want to make sure that your property is properly titled, make sure that your home and even checking accounts and different things are in the name of your trust. One thing with the real estate side of things is if your home's in a trust and you go to sell your home, the bank account that you would like to put the proceeds in does have to be in the name of your trust. So it's very easy. You'll take your trust certification down to the bank and say, I want to add the trust to my bank account, and they can easily do that. The title company will not release funds to you if you don't have a checking account in the name of the trust. So you want to stay current on trust laws, which is why you need to work with a good attorney, and then just be in communication with your trustee so that they understand your wishes and that they're prepared to carry out their responsibilities. And then review your beneficiaries, make sure that's all in order. And then I think that's all I had there. One other thing I was just going to mention before Daniel takes over is that sometimes people think because they have a will with real estate. One of our clients came to us and said, well, my dad has a will, and so I can go ahead and sell his property. That's what he put in the will. So unfortunately, the will, and Daniel can correct me, but does not provide for that if it's not in a trust. And then Daniel can also touch on regarding, like, there is a specific threshold where if you have a certain asset amount that is less than a certain number, which he can go over, then that might be an option, but you have to have the trust to avoid probate with real estate. So I'm going to turn it over to Daniel. He's going to share his screen. Towards the end, we will have a Q&A section. So we are going to answer the questions that you guys filled out when you registered for the seminar. And then feel free to raise your hand too. And Ashley, our awesome assistant's on here, so she'll monitor that, or you can put extra questions in the chat. And we're looking forward to keep going on this topic.
All right. Thank you, Jenica. Appreciate you handing the time over to me. I get all of, I think, about 15 minutes or so to talk about my favorite. Actually, if you stop screen sharing, or maybe I can just take over. Yes, I'm going to take over and share my screen. There we go. Okay, everybody should be seeing my screen now. So only 15 minutes to talk about my favorite topic of death and taxes. So I'm always super impressed with anybody who will take the time out on a, Tuesday evening to talk about death and taxes. So we're going to do that tonight. That's me. That's me wearing a suit. You guys get me in my golf shirt tonight. I apologize. I only put suits on for judges typically at this point in my career. But let's go and jump into who I am. Graduate of McGeorge out here in law school, undergrad at BYU, love BYU, season tickets, headed out there for a football game on Saturday. I'm a certified specialist in estate planning, trusts. So that's like, there's like less than 1% of attorneys in California that can claim that distinction. And that's me. I love estate planning. Done it for almost 2 years, like Jenica has been, as long as she's been doing real estate. So just shy of 2 decades. And then about our offices, that's a bunch of the attorneys there sitting down, and all the paralegals and support staff standing up behind us. We have 3 offices: Sacramento, Roseville, Folsom. All we do is in the probate code. That's all we deal with. We are specialists in that area. We don't branch into other areas. So is everybody, Jenica, can you see that thing every time I move my arrow that it like does this? Can you all see that too? Or no? Am I good? You're muted. I just want to make sure that like the screen share, that stuff that pops up on my screen, you're not seeing it.
I'm not seeing anything. Yeah.
Perfect. Okay. Just on my end. That's fine. Okay. So who needs estate planning? The real short answer is everybody needs it, because anybody, I recommend that they should at least have a will, a power of attorney, and advance directive. Literally every adult in California should at least have that to determine who's going to get what when you pass away. And also, if you can't do something, if you become incapacitated, your health takes a turn, something like that, at least having a power of attorney and advance directive will make it so that someone can assist you. Without that, then it's off to court. We go to get a conservatorship, which everybody has heard in the news recently, Britney Spears and that whole fiasco of a conservatorship. If you think probate is bad, conservatorships are even worse. So making sure that you have those things: will, power of attorney, advance directive at the bare minimum. So if you want to avoid probate, though, is something different, okay? That you actually do need to have a trust. Why would we want to avoid probate? Because in California, probates are expensive, they are very long, and they are public. So the average probate in California lasts about 18 months. That's the average, meaning some can go longer, but the absolute quickest that you can get through a probate in California is about a year. So that is before a year before your heirs would get your inheritance. That's how long it takes to get through the probate system at a minimum, like the fastest. But average, plan on about a year and a half. And then also, it's public. So COVID made this really great, where literally I don't have to travel anymore. I would have to go down to Southern California for cases about once a month prior to COVID. Now I literally never leave this desk. I make appearances all across the state right from here. That's how easy it is to go and look at any probate case that's going on. You can literally go and sign up online. You click a link and you go into the probate court, and you can sit there and watch people's estates being administered. It's public. If you don't like, you're not computer savvy or tech savvy or anything like that, here in Sacramento County, down there, Department 129 off of Power Inn, you can go in any morning at 9 o'clock, walk into the courtroom, and sit and listen to people's estates being administered. I mean, it can be interesting. And if you want your estate to be administered that way, that too could be you. All right. Cost. How much does probate cost? We talked about how long it takes on average of 18 months. We talked about that it's public. How much does it cost? So it's quite expensive. Just the personal representative and the attorney, they both get 4% of the first 100,000, 3% of the next 100,000, 2% on the next 800,000, and 1% on the next 9 million. Anything over that, half percent. So if you look at that 4%. So if you have $100,000 estate, the first $8,000 of that 100,000 are going to go to the administrator and the attorney, and then you have court fees on top of that. So it's quite expensive. I tell people kind of a rule of thumb. A trust administration generally is about a quarter of the time and a quarter of the cost of probate. That's a general rule of thumb. So something to think about there. Let's see. So as you can see at the bottom on this slide, average estate in California, 400,000. The cost, $22,000 on just that's a very, I would say, a modest estate. It's a home, really, here in the Sacramento area. Okay, does every single estate need a probate? Well, not necessarily. And this is what Jenica was mentioning earlier, is that there's a threshold that pushes you into probate. In 2024, if you've got more than $184,500 worth of total assets or real estate worth more than $61,500, then your state's going to be required to go through probate. Jenica, she's unmuted, so she can't talk right now. Jenica, can you tell me the last time that you sold a home that had a value of less than $61,500?
2007, maybe.
2007, maybe. Okay, so they don't exist, and I used my words carefully. A home, because nowadays you're not going to find a home for less than $61,500. You might find real property that's worth $61,500 or less. Like if you own a quarter acre parcel in up there in Plumas County, quarter acre, inaccessible by road. There's no utilities to it. It might be worth $10,000. That's not going to push you into probate. But if you own a home in California, I guarantee you your home is worth more than $61,500. That triggers probate. Okay. The $184,500 would be non-real property. So that's just your cash accounts, investment accounts, things like that. If you're above that, then that triggers probate. So if you're below that, then we can get away with a small state affidavit, which bypasses probate. So that's great. So typically it just boils down to every single California homeowner, they're going to be subject to probate. So best way to avoid that is creating a revocable living trust. So what is a revocable living trust? It's really a pretty simple theory. It's a contract that says, hey, I'm going to hold these assets. And then when I pass away or when I become incapacitated, this person is going to manage them for these people. And because I'm eco-friendly and green, our building has those lights that automatically shut down if they don't sense that you're there. So I just got to wave my arm around. Sorry, keep the lights on. Okay, so what is this document? You like the example that I give is like, here, I'm going to take this pen. I hold it in trust for Jenica for her benefit when I pass away. So I've just created a trust because I'm taking this pen as an individual, giving to myself as a trustee. And then when I pass away, Jenica is the beneficiary of it. That's a trust. So it's a really simple legal concept. Now, the devil's in the details because we don't suggest people just go create oral trusts or write down on a piece of paper, I hold this in trust for Jenica. Not a good idea. I've seen it done. It doesn't work out very well. Now, how do trusts work? What are their advantages? First of all, the assets that are held in your trust, they do not need to be probated. They don't need to go through this probate system of 18 months in court and expensive and public. They avoid all of that. Trust administration much cheaper. Average an average trust administration to get everything done somewhere between $5,000 to $10,000, and that's I'm talking about the administration, not to set it up. The administration when somebody passes away to get the assets out to all the beneficiaries. That's the general cost. It's private, so the only people who find out about it are the beneficiaries who are named in the trust and the trustee. That's it. And then it can also be completed much faster. Like I said, rule of thumb, a quarter of the amount of time. So 3 to 6 months. Really, quite frankly, the time that it takes to administer a trust boils down to actually Jenica's people, how long it takes to sell a house. That's generally what we're waiting on to wrap up a trust administration. Is okay, the house has been cleaned out, we've got it marketed, we've got it sold, escrow's done. All right, now we can, or escrow's closed. Now we can close up our trust administration because we've been able to sell the house. Typical package. What's involved in an estate plan? Your trust, your last will and testament. Some people say, why do I need a trust and a will? Because your will, it's a pour over will. So anything that's outside of your trust when you pass away, that your pour will is going to catch that. So your checking account that you left outside of your trust because it was a pain to put it in, your will literally controls that when you pass away, and it just dumps it into the trust. So yes, you need a will. It just dumps everything back into the trust. Your advanced healthcare directive, that's for medical decisions. Your power of attorney for financial decisions. And then a trust transfer deed to transfer, as Jenica was mentioning earlier, to transfer your real property into your trust. We take care of that as well. So a friendly reminder for those of you who already have trusts, if you have a trust and it's not funded, it's not going to do very much good when you pass away. We'll know who to send it to, but we may still have to pass through probate because you didn't put your house in the trust, or you took it out, refinanced it, didn't put it back in, and then we have to pass your house through probate. So we do a full probate and then a full trust administration. So it really just kind of messes things up if you don't get it in there. So cost range for this, an estate planning package, if it's just a will that we're doing, $1,300, $1,900. And then if it's a trust that we're doing, $2,800 to $3,400. That's the cost for setting it up, the estate plan.
When would you suggest that? Or do you mind if we go back? When would you suggest only doing a will?
Yes. I thought you meant when do I suggest doing a estate plan before you die is my suggestion. But as for it's only a will is when you are below those thresholds. Like if somebody comes to me and they're like, I don't own any real property and I've got $100,000 in my checking and savings account, then it's like, well, we don't need a trust because this estate isn't subject to probate. So we can do just a simple will, power of attorney, advance directive, save this client, a couple $1,000, $1,500 or so, something like that, and have it passed by just a will. So that's the threshold is when you look at it, say, do I own real property like a home? Okay, you're going to need a trust. If you don't own a home or real property, is your estate worth more, or is it going to be worth more potentially here in the near future, more than $184,500? If it is, then we're going to say a trust. But if it's like, no, I'm not going to get to that threshold. I'm not going to buy real property. I rent and I just live off Social Security and I have some money in savings. Okay, will's fine for them. Good question. So getting down to my time here. So a couple more slides, I think. How to create an estate plan. First off, you can go online. I don't really recommend that, but my recommendation, how to create an estate plan, meeting with a good attorney to discuss your wishes, what you want, your goal is in passing your estate on. They'll discuss with you everything that you want to do. They'll put drafts together, send it out to you for your review. You come back in, you sign all the documents, and then, that makes it official, pen to paper, notarized, and then funding the trust, putting the assets all into the trust is the next steps. Very, very important part. Usually as attorneys, we take care of the real property, and then you guys as the clients take care of going to the bank or your broker and saying, hey, I created a trust, I've got my estate plan, I want to put my accounts into it now. So the whole process, our office takes about 2 weeks from when you meet with the attorney to having it signed in effect, and then the funding, hopefully you get that done soon, going around to the banks and brokers to get that funded, but about a 2-week process on average. Okay. That's our you can go to our website and learn more. We have so many videos on there. If you think of a question dealing with estate planning, I've probably answered it and recorded a video on it that you can go to and find at our website. And then you can request a no-cost consultation, meaning that you can come and meet with one of our attorneys, me, any of our other transactional attorneys, estate planning attorneys, and have your trust reviewed at no cost, or talk about your estate plan, what you want to set up, no cost. And then we'll tell you exactly what it would cost to do that. And then I guess what we're doing here, if you schedule by the end of the month, then you get 10% off of that. That's great. Mention that you came to the seminar. And then that's it. Okay, so I will stop my screen share. And now back to Jenica, who I think maybe have
Yes,
questions that we want to go over.
I do. So we're going to start. Well, I'm going to start and ask just a few that I had, and then we'll kind of go through the list. And feel free again to put your questions in the chat, or if you feel brave and you want to raise your hand, feel free to do that and we'll call on you. So one of the questions I had, I just put in the chat. So if we do have a trust, what is your specific advice on the beneficiary for your life insurance? Should you make it your trust or should you make it your spouse?
So that's a great question. And as any good lawyer will say, it depends. That will be our answer to most of these questions, but it depends. So, my recommendation, if you love your spouse and you want them to get the money, then you name them primary beneficiary. They can get the money. And then after that, as the alternate beneficiary, you can list your trust. So that's the general recommendation. But it may be where if you have, blended families and you want that money, working with a client right now where she's married, but we're setting up a life insurance that's going to go directly to her son. So it just depends. But most people, 90% of people, they're going to name their spouse as the primary beneficiary, and then their trust is the alternate. So that if their spouse has predeceased them or passed away with them, the trustee will make the claim on the life insurance policy that dumps into the trust and then follows the distribution provisions that are in there.
Okay, thank you. So one of the questions that came in is if we currently have no kind of will or trust, what are the best resources to get started? I guess you kind of mentioned that. Come to you, schedule the consultation, and get started that way.
The absolute best resource is to come to our law firm. But to get started, honestly, you can go online and you can just read about them so that you kind of get an understanding. Like I said, going onto our website, there's hundreds of videos that you can it's obviously no pressure there. It's just you want to click around and it says, what's the difference between a trust and a will? Do I need a will if I have a trust? What's the difference between a trustee and an executor? I explain all those things. So that's a good place to start, is to just go online and start learning about these things. But then beyond that, if you're like, okay, I'm ready to, put pen to paper, then yeah, reach out to our office and get an appointment set with an attorney and we'll get you taken care of.
Okay, great. Are there any special considerations when working with blended families, and what's the best approach? And I know you briefly just kind of mentioned that.
Very much. There are special considerations when working with blended families. This is one where a blended family, I would say, if there are people who should not go and do their estate planning like online and do it themselves, it would be blended families, because there's nothing stopping you from doing that. Where like in California, if you want to self-diagnose, health condition that you have, you're welcome to do that. You can go on to WebMD, right? Figure out what you're doing, and then do whatever procedures you want on yourself. Same thing with practicing law. You can represent yourself in court. You want to go and administer your uncle's estate when he passed away. By all means, you can go into court, petition and say, I want to be the administrator, and then represent yourself in that administration. But you also get what you pay for, in that you're not going to get that representation, and you're kind of on your own. So when you do your online estate planning, the problems are always discovered when you die, right? So where do you go for recourse when the person who created the estate plan, they did it online and they're dead? You have none. You can't go and sue the internet and say this was screwed up because my mom or my dad didn't do this correctly. So really, blended families, very important to talk with a really good estate planning attorney, not just somebody who I would say says, oh yeah, I can draft a will or I can draft a trust, but like talk to somebody who is really, really good at it, because they're going to be able to guide you and say, here's where the problems will lie in this blended family situation. What is it that you want to do? What assets do you want to have there to make sure that those don't get touched, that these are going to be preserved for the kids from the previous marriage? And what assets are you fine with your surviving spouse taking those? They can spend them all, whatever. But very, very, very delicate planning that has to happen when it comes to blended families. Because I'll tell you, we do at our firm, the nice thing about it, one of the nice things about it, is that we have transactional attorneys and we have litigation attorneys in the realm of all of the probate code and trust in the states. Our transactional attorneys are the ones who set it up, and our litigation team are the ones who have to deal with the problems when they come. So many of the cases that the litigation team deals with are obviously from blended families where there's poor estate planning done. Luckily, not the planning that's done by us, but planning done by other attorneys or online, all that kind of stuff. And so many were blended families. So it's just, it can be done properly, it can be done well. It's just, I would suggest that you talk to like somebody who's really, really good at it.
Yeah. Okay. And then how do you protect against probate, which you talked about a little bit, capital gains, and how to create a lifetime tenancy?
Okay. So, a lot going on in that question. Should we start with probate? How do we avoid probate, protect from probate? That I think I mentioned probably sufficiently in there is you can spend it all, you can give it all away, or you can set up a trust. Those are kind of the options that you have to avoid probate. Literally spend every last dollar that you have and your estate's been, used, give it all away, meaning when you pass away, you literally don't have anything. You gave it away. But if you give it away, you just have to be aware of the gift tax on that. So if you try and give that all away, you're going to end up paying a bunch of tax if you're above $18,000 a year that you're giving away. And then the third one is a trust. Set up a trust, and then you're going to avoid probate. So next after that was how to avoid probate, how to avoid capital gains taxes. Also, this is something that good estate planners counsel with their clients on. So when I assume that people here have all gone through real property transactions and lesser realtors, I would say, and lesser title companies that not like Jenica, where it's like, okay, how do you want to hold title? And the people that are buying this house, they look back at the realtor, the escrow agent. Well, how do most people hold it? And they just say joint tenants, and they mark the box of joint tenants or whatever, and then we draft up a deed, and they sit there and hold it as joint tenants. Well, joint tenants, you only are going to get a half step up in basis as opposed to full steps up in basis when you hold the property as community property. So what that means is that if you hold it as joint tenants and then one spouse passes away and then the surviving spouse decides, hey, I want to go and sell this property. Well, the basis, this half of the property gets to step up the basis to whatever the date of death value was, half of it at the deceased spouse, but then their half doesn't get stepped up. So that means they're going to pay more in capital gains tax as opposed to if they had put it into a trust, then they get a full step up in basis. So that same married couple, if they put their asset into a trust and then the first spouse passes away, they get to step up the basis all the way to the fair market value when the first spouse passed away. And now they can sell it and conceivably pay no capital gains tax if they're selling it, near the time of that first death. This happens with clients frequently that we deal with, where I can remember one where it's like they had a beach house down in Southern California. They'd had it forever, and now the thing was, their basis was like $100,000 in it. Now it was worth over $1 million. So they were looking at a gain of 900,000, $1 million, and you're talking, capital gains tax there of maybe $250,000. But because they had held it in a trust, first spouse has passed away. It was community property. They stepped up the basis all the way to the fair market value that it was at the date of death. It was like $1 million. She turned around and sold it and paid zero in capital gains tax. So how to avoid capital gains tax? Putting it in a trust. If it's community property being put in that trust, then you get a double step up the basis. So first spouse passes away, step the basis all the way up. Last spouse passes away, step it up again. Kids inherit it. That's their basis. They can turn around, sell it, pay no capital gains tax. As opposed to joint tenancy, it's only a half step up on that death. So that's kind of a capital gains tax 101. Hopefully that makes sense. But in California, that's the way that most people avoid capital gains taxes is placing it into trust. When there's a death, we get to step up the basis, avoid those taxes. And then the last one was, how do you create a life tenancy? I think was the last part of that.
Lifetime tenancy. Can I ask one question on the capital gains? I think you kind of mentioned it, but then with the, 250 for each spouse, 500,000 together, does that come off of that?
So
let's say there's that gain.
So as long as you've utilized it right 2 out of the last 5 years. So if you're single, you can say, hey, I've got my $250,000 exemption. You can use that. If you're married, I've got my $500,000 exemption. You can use that if you've used it to the last 5 years. But with that's on your obviously your primary residence.
Mhm.
Other property, real property, obviously that doesn't apply, but it still
Mhm.
does apply for trusts. So if it was community property, doesn't matter if it was your primary residence and your spouse passes away, we get to step up the basis to the fair market value on that investment property that they had. So yeah, great
Okay.
clarification.
Okay, perfect. So yeah, the other one was how to create a lifetime tenancy.
Yeah, so a life tenant, you say, okay, I'm gonna I want to leave property to somebody, and I want them to be able to enjoy it during their lifetime. But then when they pass away, I want to leave it to the remainderment, is what they're called. So you can create that with literally, you can create it with a deed, a life tenants deed, where you say, okay, I'm leaving a life tenancy to Jenica, so Jenica gets the use of that property during her lifetime. She can use it really as she wants to. She can live in there. She can rent it out. What she just can't do is like burn the thing down. So that the remainderman would show up and be like, "Hey, you're burning our property down. Could you not do that? Because that's ours once you pass away." But that can be done with a deed. It can be done with a will, where you leave a life tenancy to somebody, or in a trust. You can also do that. You can create a interest for their life in your trust and say, okay, this property up in Folsom, I'm going to leave to Jenica. I'm going to have it held in trust for her life. Trustee's going to manage it. Jenica is going to be responsible for XYZ. Trust will be responsible for ABC, and then the trustee manages that, which is different than just a life tenancy deed. Because a life tenancy deed, where it's like you go file that deed, they're the life tenant on it, they can use it, and then when they pass away, the remaindermen that have to be mentioned on that deed, that's a big problem if you have a life tenancy deed that doesn't have a remainderman. That's not the correct way of doing things. But when that life tenant passes away, it automatically you file a death certificate, and the remaindermen then take the control of the property. They take the ownership of the property. So several different ways to create it. Just depends on the situation as to what's going to be the best fit. So that's where I would counsel with an attorney on that.
Okay, thank you. The next question, if I have a spouse who's incapacitated, our home is in a trust, and we have a power of attorney, can I sell the house by signing for them?
So depends if that power of attorney has trust powers in it, because you could have a power of attorney where, assuming the house is held in the trust, you could have a power of attorney where it's like, okay, yeah, my spouse can act as my agent. But if the power of attorney doesn't mention anything about the trust, then you may have the title companies who may have a problem with you transferring the property, because they're saying, hey, you have a power of attorney with their power as an individual, but they're not holding this as an individual. They're holding it as a trustee. So if the power of attorney mentions that they're granting it as an individual and as a trustee of a trust, then you could probably use that power of attorney. But if not, then and somebody and your spouse is incapacitated, then you should probably be looking at the terms of the trust that would likely say, incapacitated trustees, here's how to remove them. 2 doctor's letters that state they can no longer manage their affairs. Remove them as a trustee of the trust, and then that leaves the sole trustee. They can then obviously sign off on the real property. If they say, okay, affidavit of change of trustee, this trustee was incapacitated, we're taking them off title. That leaves the well spouse as the sole trustee. They can now transfer title and sell the house. So
Okay, okay. And something else, I know sometimes people will say, oh, I have a power of attorney I can sign for my spouse, even not dealing with the incapacity situation. And it's like, no, it has to be a power of attorney for real estate. So people think they can sign, and the title company
sure.
always tells me it has to be a power of attorney, and for a specific property even, I think. I've gotten that from the title company before, not necessarily dealing with the trust.
I mean, that's aggressive from a title company. I would say that we have to have a power of attorney that mentions this specific property, because most powers of attorney, they're going to have like a list of like 20 different things where it's like, okay, can they deal with taxes? Can they deal with business operations? Can they deal with real property transactions? All this kind of stuff. and then all of the
Maybe
above.
that's what I mean, is
Yeah,
sometimes people have a power of attorney that doesn't mention real property,
sure.
but people think, oh, I have power of attorney for my, spouse while they're overseas. It's like, well, it has to mention real
Yeah,
property. You
if it
can't.
doesn't grant the authority to handle real property transactions, it's not going to work.
Yeah.
Right?
Okay.
You should specifically tailor those for sure.
Okay. And then you talked about community property versus joint tenancy. So then uh, pros and cons of having a trust. So anything you didn't maybe hit on in your slides.
Um, Cons of having a trust. Mm. The cons of having a trust, probably that it costs a little bit of money to set up. Um, but beyond that, I can't think of many, honestly. And then pros of having a trust, obviously the probate avoidance, capital gains tax reduction. The if you become incapacitated, there's a plan. We don't have to go off and get a conservatorship, so it avoids conservatorships. It avoids probate. It reduces your taxes. It keeps things private upon your passing. There's a lot of benefits there. Pros, I would say, with having the trust. The cons for having the trust, honestly, cost, and then making sure that you keep title on your assets in your trust. That's kind of a pain, maybe, because it's like, oh, I gotta go to the bank. I hate going to the bank. It's working with the dentist. But you got to do that. So there you go. There's a con.
Okay. So everybody needs to get a trust. If you're over that threshold, get a trust.
Yeah.
Right? Okay. The cost to set up a trust, you've briefly mentioned it. Do you mind?
Yeah. So for single people, they're going to be looking at ballpark about $2,900 around there. The more pieces of real property you have, the more expensive it gets, just because we, the attorney, we handle drafting the deed and getting that recorded with the counties where you own it. So it's more work with the more pieces of real property that you own. So it starts at 2,900, goes up from there. And then married couples for a couple, $3,400. And that's, once again, includes one piece of real property. If you own multiple pieces of property, the cost is going to go up a couple $100 each time every new deed we have to draft. So there's your general cost.
Okay. And then can a new property be added to a trust years later?
Very much so. That's why people say, "Oh, do I have to come and tell you every time I, get an asset or buy a piece of property or anything like that?" No, you don't. Just make sure that when you're closing on the property and you're going to be seeing that deed that the sellers are signing over to you, make sure that it's in your trust. So, yeah, you can take assets out, put assets in, all that kind of stuff with your certification of trust, little document that says, here's what the name of the trust is, here's who the trustees are, here's the tax ID number, here's all the powers that they have. Like 5-page document typically. Just use that a lot. When you go and you're buying a piece of property, say, I've got a trust, make sure that it's put in there. You're opening up a bank account, I've got a trust, make sure it's put in there. So yes, take in, put out as you wish.
Okay. And yeah, I'll say too, I feel like years ago in the real estate industry, lenders would kind of dissuade people from doing the purchase in the trust and say, oh, just do it when it's done. It's easier. I feel
Yep.
like now we just do it right out of the gate and it's been fine. So I
Yeah.
would say it's almost easier, just make sure it's on the contract when
Yep.
you go to close on the property.
Yeah.
And if you are going to do it later or you refinance and take it out, just make sure to put it back in because it's one of those things people say, I know I need to do it. I know I need to
Yep.
do it. And then
Yeah.
time goes on and.
No, it's getting much better. Like, yeah, lenders were super skittish about involving the trust at all because they're like, oh, it's one of these irrevocable trusts where we don't get access to the assets if we have to foreclose. No, that's not it. This is a revocable trust. It's like it's literally, it doesn't affect the security interest at all. So banks are getting much better about recognizing that and saying, yeah. And also, it used to be where anytime there was a refinance, banks would be taking the property out of the trust, completing the loan and then not putting it back in, and just, excuse my French, screwing so many people over because then
Yeah.
they don't mention that to us. They refinance their house and they die, and then who finds out? The kids find out when we pull title. Your mom and dad refinanced the house and never put it back in the trust, and so now it's outside of the trust. We got to go, and at least we would be filing with what they're called Hegstead petitions, an 850 petition, going to the court and explaining to them these people put it in their trust. This bank took it out to refinance their loan and never put it back in. So please don't make us go through a full probate. Just give us an order that confirms that this is a trust asset and not make us go through the full blown probate. And we would always, get those orders. But yeah, it costs a couple $1,000s more to go and do that in a couple months of time. So,
Okay, good to know. One other question about the pour over will that you mentioned, would cars be included in that? The pour over
so
will for assets?
yes, because cars, those don't trigger a probate because if somebody has a car that's worth more than $184,500, that's where it's like, okay, we're going to be
The
triggered.
Tesla truck, maybe
Most people, yeah, most people
upgraded.
are not driving around cars that are worth that much. So it's signing a small state affidavit with the DMV and saying, "Yep, I'm the person who's entitled to take title to this car." Sign that after 45 days from the date of death. DMV transfers title. So cars are handled, yeah, in the will. We don't have to go and change the title on our cars.
Okay, good to know. Someone asked, are there any costs associated with trusts that are passed on to heirs?
Just the administration. So, like I said, the cost that's passed on to the heirs is when you're administering that trust. I would strongly suggest that the trustee gets the advice and counsel of an attorney to guide him through the trust administration. Um, so that trustee can utilize trust funds to pay for the representation of the attorney. And obviously, if you're selling a property and you're going to pay a realtor's commission, that's going to come out of the trust funds eventually as well. So the estate administration expenses, those get paid for by the trust. But what are the costs that get passed on to the beneficiaries? Well, it's those because essentially everything, the whole trust belongs to the beneficiaries, but there's some costs with administering it. You pay those off the top, whatever's left, give that to the beneficiaries.
Okay. Let's see. And then how does a living trust function? I think you kind of hit on those points. I don't know if you want to add anything else.
I mean, yeah, hopefully it functions well because you're going to manage it for yourself while you're alive. And then when you pass away, the terms kick in that say, okay, here's the successor trustee. They go out, find the assets, take title to it, and then administer those for the benefit of the beneficiaries according to the terms that were set up. So the function of it is a trustee that's taking title, actually going on title to a bank account, going on title to a piece of real property, and managing that, whether it means investing it, selling it for the beneficiary. And then they cut checks to those beneficiaries, and here's your inheritance. So.
Okay. And then when you were talking about costs that are associated, I want to say when you mentioned probate too, the administrator / executor, depending on which one, gets paid for their, so that was interesting when we were dealing with a probate case, they got,
percentage of the estate. Yeah.
For doing that work. Okay. Yep. Somebody's asking if there's different types of trusts.
Yeah, a lot. There are a lot of different types of trusts. So depending on what the goal is of the client, that determines what we're going to use. 90% of trusts are going to be your standard revocable trust. Beyond that, we get into a lot of different kinds of irrevocable trusts, where that means you're putting assets into a trust and then you're actually giving up control of it, whether that be to avoid federal estate taxes, whether that be to avoid creditors possibly, whether that be to get qualified for a government benefit. So you're giving up control. But a lot of it, the irrevocable trusts are actually dealing with reducing the federal estate taxes, where we want to get assets out of your estate and let it grow in an irrevocable trust so that you don't get taxed more when you pass away. But yeah, lots of different kinds of trusts. 9 times out of 10, the revocable trust is the standard that's going to get you your goals of avoiding probate and avoiding capital gains tax and avoiding federal estate taxes. Because right now we have a fairly high federal estate tax exemption, $13.6 million in change. So if you have more than that, then you got to worry about the federal estate tax. Less than that, a revocable trust is gonna get it done for you.
Okay. And we have a client who dealt with probate, represented herself, and she's the one that's telling everybody, go get a trust. But somebody in her family has is on public assistance and then needed to have a special needs trust done so
Right.
that her public assistance wouldn't get taken away. And that's a
Right.
whole nother layer, which is why you just need to have someone counseling you so that,
Yep.
you know,
Yep.
so many different.
We deal with those as well. Special needs trust, so that once again they don't lose their benefits.
Yes, yes. Okay. Next question is, what are the duties of being named the executor in a trust?
So your duties, and when you say an executor of a trust, I think what they meant was trustee of a trust. Executors function under wills in the probate court. Trustees function under trusts. But when you're named the trustee of a trust, your duties are to the beneficiaries. You have a duty you have a duty to account to them. You have a fiduciary duties that say, okay, you have to act in the best interest of the beneficiaries. You have a duty to provide information to these beneficiaries. Really, where it's like the beneficiaries are the ones who can ask the questions, and the trustees have to answer that. It's, what are you doing with my money? Where is it at? What's your plan with it? Why do I not have it yet? But that's essentially all beneficiaries. They have two questions: how much do I get and when? And the fiduciary duties are to the beneficiaries to make sure that you give them as much money as possible, as quick as possible. That's kind of boiled down to as simple terms as it comes. Your duties that you have as a trustee is to take care of the trust estate. Don't let it go to waste. Don't let money get spent unnecessarily. So, and to report that to the beneficiaries. So,
Okay. Let's see. Can I do a beneficiary deed to my daughters for my house in case of my death instead of a trust?
So yes, it's called a transfer on death deed. This was, they created this, what year was it? Somewhere around 2013, 14, somewhere around there. And they're like, okay, we want to try this out. Great transfer on death deeds. Not a lot of estate planners that love them because it's fraught with the potential for abuse, where it's like, here, sign this deed, and then it's going to go to the caregiver, the one child instead of equally to the three. So that's something that you can do. It's a deed. It's a transfer on death. Here, I'm going to sign this, and when I die, this property transfers to my daughter, my son, whomever. And yes, they get a full step up in basis, so that's nice. But if that daughter or son, passes away, then well, what do we do now? It really doesn't do anything. It's off to probate we go to figure out what to do with it. So yes, you absolutely can do a transfer on death deed. I just would I'd counsel with an attorney on if that's going to accomplish your goals, given what they are, and if that's the best way to do it. Yeah, you can do it.
Okay. The next question is, when one trustee of the trust dies, how does the tax basis change related to investments and equities?
So I presume that that it's actually the settlor, because a trustee dying, that's the person who manages it, doesn't really have an effect on it doesn't at all have an effect on the tax base. It's a settlor, the person who owned it, that had the beneficial interest, that set up the trust. When they pass away, so if this is a married couple, like we said before, and it's community property, when one spouse passes away, all community property assets get a full step up in basis. So that means that if the two of these married couple bought a house for $100,000 way back in the day, and it's worth $750,000 now, when that first spouse passes away, the new basis in it is $750,000. Surviving spouse can turn around, sell the property, and pay no tax, and not even use their homeowner's exemption. And then they can go buy some other property with that, and then that's their basis in it, and they get another step up in basis when they pass away. So that's why we call it the double step up in basis. That's how it works with married couples. First spouse passes away, community property, full step up in basis. Second spouse passes away, another full step on basis. Kids, heirs, they take the property, and their basis is the fair market value of whatever the asset was at the date of death of the second settler, so they can turn around, pay no capital gains tax when they sell it, realize the gain.
Okay. And then while we're on this topic real fast, with the kids, when they're inheriting these properties, with that new proposition, though, if they don't move into it, they will reassess the taxes.
Yeah. So first $1 million on property gets exempt from property taxes. property tax reassessment, but they got to be living in the property. So it's great that you can use it and avoid a property tax increase if that kid's going to live in the property. If they're not, they're using it as a rental or something like that. The property taxes are going to get reassessed. So this, I mean, and this goes all back to making sure that people can move, downsize.
Right.
That before it was only intercounty, like counties had to have agreements between one another. If they would honor, somebody's over 55, they sold their house, and they're going to move over to El Dorado County, and they were from
Yes.
Sacramento County. We're going to allow that. But now statewide, you can move anywhere in the state. If you're over the age of 55, and take your property taxes, your low property tax basis, with you anywhere in the state. And the trade-off was this: that after that first $1 million, they're going to reassess the property. So heirs, children will have the property tax basis reassessed up higher, and they're going to they'll see their property taxes triple, quadruple because of that.
So the $1 million is the exemption is if you move in there, there's a $1 million exemption.
Correct. It's that first $1 million. So like if their property tax basis, they bought it for $200,000, and now the property's worth $1.2 million, they can keep their same property tax basis if they're living in the property. But if that $200,000 property is now $2 million, the first one, that $1.2 million, they keep the same property tax basis, but that $800,000, that's going to be reassessed. They're going to see that added on to the property tax bill.
Okay. Okay. One other thing too that we ran into with probate is that they dealt with a supplemental tax bill, which came into play, where we thought, how they didn't even,
where'd this come from?
She never lived in it. They transferred to her during probate, and then she received a supplemental bill. And I thought that was, unforeseen.
Yep. They sometimes come late.
Yes.
The tax man always comes.
Yes, he does. And then we have somebody who has quite a bit of wealth, if you will, and then doesn't feel like maybe they need a trust because they don't have any heirs. So like, why, if somebody doesn't have heirs, why would they create a trust if they're not maybe concerned about passing it on?
Yeah, then they don't need to. That happens too, where it's like they're like, I don't care if my estate passes through probate. I'll let them handle it, and go through that process. By all means, they don't need it, and if they become incapacitated and they're fine with everything going off to a conservatorship, then by all means, do it. It is, I mean, it's a process. It will happen where it's going to go to, if they don't set up a will or trust or anything like that, it's going to go by intestate succession. So the state of California decides who gets your property if you don't. And if they don't have the interest to say, hey, I don't have any heirs. I mean, everybody has heirs. Everyone has heirs. Like, even if you don't have children, you got heirs. It might be your siblings. It might be your parents. It might be a very distant cousin if that's the nearest living relative. But that's your heir. So as they say, well, I don't care. I don't care about avoiding probate. Okay, that's fine.
Yeah. Okay. Maybe spending it or giving it all away is a good idea. I mean, I like how you said you either spend it all, give it all away, or get a trust. Like that's a simple way to say here's the options. Okay. Let's see. How does inheritance of one house work if only one of the parents passed away?
So I would probably need a little bit of clarification on that, as to what exactly that meant, but I can maybe take a guess at it. So if whatever their estate plan is, if you have a couple that has community property and they own a house, and the first spouse passes away, they get to decide what happens with their half interest in that community property. If they say, hey, it's joint tenancy, then their estate planning decision was, if they die first, the surviving joint tenant gets everything. So in that case, where it's like, well, nothing, you don't inherit anything if you're an heir of this deceased spouse. It all, as joint tenants, by the function of joint tenancy, it all goes to this spouse, and then whatever their estate plan says, whether it's in their will or their trust, that's going to determine where it passes when they pass away. But if they say, okay, my half interest I want to leave to my kid when I pass away, and they didn't hold it in joint tenancy, they held it in a trust, then okay, well, your half interest, this deceased spouse, is going to go to the children, and then this surviving spouse and this the children are going to have to decide, what are we going to do with this property? We're going to, keep it and you can rent, pay us rent, or are you we're going to sell this and split it? So it depends on what the deceased spouse's estate plan said, honestly, is the answer to that. So if it was, I want it all to go to my spouse, okay. If it's, I want my spouse to be able to use it while they're alive, but then go down to my children when they pass away, then okay, it sounds like that's held in the trust, and there may be accounting that is required to give to the beneficiaries, but it just depends on what their estate plan says. So that's
Okay.
why
And
back to the importance of blended families, talking to a good estate planner to figure that out.
attorney.
Yep.
Do you think so in the trust, does it state whether it's community property or joint tenancy?
Most definitely. The trust is going to, should a good
In
trust,
that it should have that.
yeah, this is community property, this is separate property. So it should have that on. Generally, it's a trust will have like a schedule A, B, and C. Schedule A being community property, Schedule B being separate property, and Schedule C being separate property of the two different spouses.
Okay, that's good to know. Okay, let's see. We're gonna go to the chat. So, how often do you suggest updating the trust, and what are the costs for that?
Updating, I mean, I tell my clients, come and see me about every 5 years. I'm not like your dentist that I want to see you every 6 months. I say about every 5 years. Even my clients who are like in their 30s and 40s, I tell them maybe every 10 years. Once you get up into your 60s and 70s, where I look at a lot of death certificates, and there's a lot of people in their 70s with that age when they pass away. So people in their 60s and 70s, they come see me every 5 years to make sure your estate plan is still in good order. And then how much does it cost? I mean, to make a change, like just a simple amendment, distribution, that's going to be like $500. If you're changing your trustees, that's more expensive, because the change of trustees requires an amendment, a new certification trust, a new will, and typically your powers of attorney, and a lot of times your advance directive as to all those. So those like start like $1,000 to change your trustees and agents. But yeah, to just come sit down with my clients, where it's like, yeah, to come and sit down and go through everything, we give a discounted off of our hourly rate. So I think it's like $400 off of my $400, which is a discount off my normal hourly rate, to come and sit down and go through everything with me.
Okay. Thank you. And what about adding timeshare deeds to the trust?
You can do that. I don't deal with those because it's not cost effective for the timeshares, because timeshares, it is a real property interest, but once again, most timeshares, they're not going to be above that 61,500 and trigger probate. So that's why we don't deal with them, because it's just too expensive to have an attorney deal with that, where it's not even going to trigger a probate. Generally, it's dealt with through the timeshare company, because if you die and it's just in your name and not in your trust, it's not going to be a probate. They're going to be able to do a small state affidavit, pass it on to the heirs. So that's why we deal with it through the timeshare company.
Okay. And then what about property that's owned in 2 different states? Does that?
All the more reason to get your estate planning done, because if you own property in one state and property in another state, if you pass away, you could be having a probate here in this state where you were resident, and then an ancillary probate has to be open in the state where you own property. All the more reason to own, to create a trust, so that you're not having probates in 2 different states, because a probate in California will not transfer property in Nevada, Arizona, Missouri, whatever. Our courts have no determination as to what happens to real property in those states.
Okay, that's good to know. Let's see. Okay, we talked about that. If your home is in a trust, do you need to put the trust on the homeowner insurance policy?
No, because the contract with the company is that they're insuring that home at this address against loss, destruction, fire, all that kind of stuff. So it doesn't matter if it's in a trust or not. So no, our clients, they don't have to go and make sure that the trust is a covered, entity. It's the home insurance is going to cover it.
Okay. And then can you explain the difference versus trustee versus executor? I know you kind of touched on it maybe a tiny bit.
The trustees function under trusts. Executors function under the will, under the purview of the probate. So an executor actually has to be appointed by the probate court. So the whole goal, we cross our fingers, is that an executor will never be appointed on somebody's estate. The trustee of the trust will manage the trust assets. And an executor should hopefully not be appointed, because executors have to be, the petition has to be sent to the court. Here's the will of the person that died. I'm appointed executor. Give me an order granting me letters testamentary that say this person go out and collect the assets of the decedent. So executors function under the will in the probate court. Trustees function under the trust in a trust administration, private.
Okay. And then what about the administrator? Because that's also on the probate side.
Yeah, an administrator is the same thing as an executor. It's just there was no will. So the administrator of the estate means somebody died intestate. They didn't have a will, and we're going to appoint an administrator. An executor is somebody died with a will, and they appointed an executor. But they do the same thing in the probate, in the estate process.
Okay. Great. Well, that's all of our questions. Thank you so much for everybody for being here tonight. Hopefully you got a lot of information. I took notes, and hopefully you'll all go out and get a trust if you don't have one, tell your friends, and just so we can all be protected, should the unfortunate happen, and leave our loved ones with, less stress in the process. Because
bad enough. No, it's been a pleasure. Thank you, Jennifer, for setting this up and having me. It's been awesome.
No problem. And we'll have Dan's information out in an email to you guys as well. And as always, we're here for your real estate needs and questions. And we hope that this was valuable and that we will keep bringing value to you and just being a resource. So thank you, everybody, for being here.
Evening, everybody.
Have a good night. Bye.
Bye.